Hello and welcome to the April edition of the DVAP Monthly MCLE series. We're happy to have you all joining us virtually. As a reminder, this session is a webinar, so while you won't be able to interact directly with our speaker, please feel free to enter any questions or comments in the Q&A box at the bottom of your screen. All questions will be answered at the end of the presentation, time permitting. Additionally, a copy of the presentation will be provided to all attendees as well as the MCLE course number. Today, we have the pleasure of having Robert Yaquinto, an experienced bankruptcy attorney and longtime DVAP volunteer, present for us. So without further ado, I will go ahead and pass it to Robert. Thank you,
Thank
Robert.
you. Thank you, Maricela. As Maricela said, I'm Robert Yaquinto. I go by Rob. I have been on the Chapter 7 panel of trustees for the Northern District of Texas for over 30 years. I've been doing bankruptcy work for longer than that. I have done a fair amount of volunteering with the Dallas Volunteer Attorney Program in representing people that are unable to afford attorneys. It's actually a real pleasure to be able to deal with some of these people. Some people, not so much, but you figure that out and you deal with them however you can. So what I thought I would do is kind of go through the process of getting the referral from DVAP, and then what you need to do to when you get the referral, some of the things that occur occasionally, and then walk you all through the process of filing a bankruptcy, and maybe give you all some places to go to get forms or other information that you might want in representing your clients, your volunteer attorney program clients. So typically how it works is you'll get an email from the Dallas Volunteer Attorney Program asking if you can take a case. And if you can, you respond, and then they will send you a case. And typically, the DVAP has already kind of vetted the client. They meet the qualifications for the Dallas Volunteer Attorney Program. And I found that about 90% of the people that have contacted DVAP are pretty motivated to get something done. I've also found that one of the issues for a lot of the people that contact DVAP is that they don't really understand how bankruptcy works or what they need to do and what the process is. And so the first thing I do is I go through the file and I make sure that that I've reviewed it and I have an idea of what they've told the intake person and what their problems are. Um, uh, Sometimes you will get a client who actually looks like they really, I mean, it would bankruptcy is a pretty drastic measure. And sometimes you look at these cases and you wonder if whether they shouldn't just wait this out or not. And so one of the first things I do is I go through the information with them, and make sure that they understand that they don't necessarily have to file bankruptcy. I try to understand why they're motivated to file bankruptcy. And then once they've come to the conclusion, and I've come to the conclusion that this is going to work in their best interest, then we proceed to trying to prepare them to file bankruptcy. Now, one of the things when you look at the Dallas Volunteer Attorney Program file that you receive, you need to look to see if there are any kind of unusual circumstances. So most of the people that are referred by DVAP are not going to own real estate. They're going to have lease agreements, and you're going to need to look and see whether or not their lease is current or if they're having issues with their landlord. Those can be issues that are beyond the scope of the bankruptcy, or they can be dealt with in the bankruptcy if in fact the client is prepared to deal with them. In other words, catch up on the rent or find another place to move to. The way bankruptcy works is the client has to take what's called a consumer credit counseling course. There are a number of services that are available to provide this service. If your client meets the requirements, and most of the clients that go to DVAP do, you can ask this service to waive the fee. The fees are anywhere from $25 to $50. They're typically fairly inexpensive, but most of the people that come to you from DVAP don't really have the money to pay for this stuff. So you have to find the service and ask them to waive the fee. The service we use is Abacus, and there are others, but we've dealt with them for a long time, and they've been very helpful. So, so once you get again, you go back, you get the file. I always like to meet with my clients in person, so I ask them to come to my office. For the most part, the only time that any of the clients are going to have really any real interaction with the bankruptcy system is going to be with you and with a bankruptcy trustee. They may never see a bankruptcy judge. So it's important that you meet, in my mind, important that you meet with them, talk to them personally, and make sure that they're going to follow through on this stuff. Then we use a questionnaire to supplement the information that we've gotten from the Dallas Volunteer Attorney Program. There are a number of the consumer bankruptcy programs have their own questionnaire or brochure that that the client fills out that provides a lot of the information that you need in order to complete the petition, the schedules, and the statement of financial affairs. And so we have the client come in, and then we go over the questionnaire and we give it back. We give it to them and ask them to fill it out. And when they filled it out, to bring it back to us or to email it to us if they have the ability to do that. Once we get the questionnaire back, we go through it. Our legal assistant inputs the information into the program that we use. We get a draft. We go through the draft. We make sure that we've got all of the information. We send the draft to the client. We have the client go through it. When the client, then we have the client come in to sign the documents, because you have to have a wet signature, even though you're going to put an electronic signature on the document that you file. And let me go back for a second to the referral. Generally, the client will call you, and that's the way it's set up. They're given your phone number, and the client calls you. But I've had one referral that I ended up having to call him, and I tried him several times, and he didn't really respond, and I reported that to DVAP, and I don't know if they ever contacted him again, but that was the end of the case for me. But sometimes that happens too. You get a referral and they don't call you, and so you make an effort to call them, and if they don't respond, then you just report it to DVAP, and they'll take it from there. Okay, so most of the clients that you have that come from DVAP are not terribly sophisticated. They're generally smart, and they know that they need help, but they haven't ever really dealt with a lawyer, and they haven't really ever dealt with bankruptcy forms or actually been part of the bankruptcy system. So that's also part of dealing with the clients when they come in or when you meet with them. You go through, you make sure that they have an understanding of how all of this works. Sometimes you'll spend a lot of time making sure, making sure they understand, and then then you will work with them, and they will respond to you, I think, fairly promptly once they feel comfortable with you and know that you're operating in their best interest. Um, so, as I said, before you can file a bankruptcy, you have to take there's a statutory requirement that you take a consumer that the debtor take a consumer credit counseling course. Those are anywhere from 30 to 60 minutes. They can be taken by telephone or they can be taken online. Typically, it's easier to take them online. They're like defensive driving. There are sections, they're timed. You can finish a section, but you can't go to the next section until you're timed out. Once that's completed, typically the service will send you a certificate. When I say you, send you the lawyer the certificate. They'll also send a copy to your client. And then that has to be filed with the court at the time that you file the petition in bankruptcy. So, so you've got the consumer credit counseling course. Now you're ready to file the petition in bankruptcy. So there are forms that are uniform that are used throughout the United States. And if you don't have access to a consumer bankruptcy program that you can use, the Northern District of Texas, as do most bankruptcy courts, has a website, and you can go into the website, and there's a menu across the top. It's a horizontal menu, and it has a button for forms. You hit forms, and a menu will drop down, and there'll be two selections. You'll select the national forms, and then you can go in and you can pull up all of the schedules, and the schedules that are on this on this website are interactive, so you can fill them in and then download them and save them. So you complete the schedules, you complete the statement of financial affairs, there'll be a statement of intent. Um, and you'll file those with the court. And everything is done electronically. So if you're not registered with the Northern District of Texas as an electronic case filer, you'll have to do that. It's possible to take them to the clerk's office and they will scan them in and file them for you, but it's a lot easier if you can file them electronically from your office. Once the petition petition and the schedule of statement of financial affairs is filed, and let me go back. We typically avoid this, especially in these cases. You want to file everything at one time. You want to file the petition, the matrix, the schedules, the statement of financial affairs, the statement of intent, all at one time so that it's done and you don't have to worry about deadlines. It's possible to file a petition and the matrix. It's actually possible to file a petition, then would have 48 hours to file a matrix with the court, mailing matrix. That's what they use to send notice to the creditors. And then you would have 14 days from the date of filing to file your schedules. That can be extended by motion and order, but you really want to avoid that if you can. So the case is filed. The court, it's assigned to a court, and here in Dallas, there are three bankruptcy courts. Judge Jernigan, Judge Larson, and Judge Everett are the bankruptcy judges here. You'll be assigned to one of those courts, and then a trustee will be assigned to your case. And let me make a plug for trustees at this point. So when you're doing this, you're really helping the trustee. You're not only helping your client, but you're helping the trustee. You're making it more efficient. and a little bit more simple for the trustee to review the schedules, the petition, the schedules, and statement of financial affairs, and make a quick determination that this is a no asset case. Most of these are going to be no asset cases. But the fact that you're there and you can represent the client and can ask the questions, and you've gone through all of the schedules and the statement of financial affairs with the client and beforehand, and hopefully you've gone over this stuff and prepared the client for the meeting, that'll make it a much smoother meeting. It'll make it easier for the trustee. Now, let me stop here for a second. Um, it is there are a list of questions that trustees are required, or they're asked to ask. It's in the trustee handbook. There are about 10 or 15 questions. Those questions are available. You can go into, you can look up the Chapter 7 Trustees Handbook. You can Google it, and you can look at, they'll have a list of questions that the trustees are expected to ask. It would make sense and would be a smart thing to do to go into the trustee handbook and download that list of questions so that you have at least the outline of the questions that need to be asked as far as the U.S. Trustees Program is concerned, and really probably most of the questions that will be asked in the course of the Chapter 7 creditors meeting. The creditors meeting is generally set somewhere between 30 and 40 days from the date of the filing of the petition in bankruptcy. All of the creditors meetings are now done on Zoom. So once the notice of the meeting of creditors is sent out, there is a Zoom link on that notice, and that is the Zoom link that you will use and that your client will use in order to join the meeting. Some trustees only let the people into the meeting room who are scheduled to meet at that time. And they'll just take them in the order that they have them on their docket. And if they need to jump out of order, they will. But typically, it's just done in the order that the cases are lined up. There are other trustees like me, and I let everybody in all at once because sometimes it gets a little distracting, and because people fail to mute their microphones. But that's easy to handle. There are devices. I mean, there are ways that the trustee can mute the microphone, but I think it's a good idea because it gives your clients, especially if they get on a few minutes early, it gives your clients an opportunity to kind of see how the meeting works, to see the questions that are asked, to kind of give them an opportunity to get maybe a little comfortable with the process and with the meeting format, so that they're not quite as nervous as they might be. So you go through the meeting, and some trustees ask a lot of questions. Some trustees let you ask all the questions. So that's why it's handy to have that list of questions to make sure you cover at least the basic information. Some of the things some of the things that you need to really kind of look for when you're representing your clients. A lot of the clients that come to you have student loans, and those student loans are not, at least at this point in time, are not generally not dischargeable in bankruptcy. That's not part of your undertaking when you volunteer to take take a case. And you need to make that clear to the client that you're going to represent the client in the bankruptcy, but you're not going to file an adversary proceeding to try to avoid their student debt. Now, if you choose to undertake that and you want to do it, that's up to you, but that's not part of the program here. When you file the bankruptcy, again, if the client that you have meets certain requirements, the filing fee can be waived. There's a form on the national forms that allow you to to request the court to allow the client to proceed to file the bankruptcy in informa pauperis, IFP. It waives the filing fee, uh, and so it saves them $338. Um, Similarly, if there are any amendments to the schedules, there's a filing fee for that, and that also can be waived. Um, so once the meeting is concluded, parties and interests and creditors have 30 days within which to file objections to the exemptions. And let's talk about exemptions for a moment. In Texas, we're allowed to choose between federal and state exemptions. State exemptions are very generous in the homestead and in the personal property exemptions, but the state exemptions have no way to exempt cash. The federal exemptions, on the other hand, are not as generous, but they have a way for you to exempt cash for your client. Not that a lot of people that are using the volunteer attorney program have cash, but sometimes they'll have $3,000 or $4,000 in the bank because they've gotten paid, or that's just money that they've saved. And you want to claim that exempt. As I said, most of your referrals from Dallas Volunteer Attorney Program are not going to own real estate, so you're going to be looking at the federal exemptions. So you need to bear that in mind when you're discussing the bankruptcy with your clients. Creditors have 60 days from the date of the meeting of the creditors within which to file complaints objecting to discharge or complaints to determine dischargeability. Not likely to happen in a DVAP referral. There may be some other unusual issues that you need to look at. For instance, if the person who's filing is married and their spouse is either estranged or not joining in the bankruptcy, you want to make sure that the spouse doesn't have any unusual or valuable property that might be community property, because the community property is property of the estate. You also want to look at the previous history of the debtor. You want to make sure that the debtor hasn't filed bankruptcy within the 8 years immediately preceding the one that you're going to file for the debtor, because there's a bar to filing until 8 years have elapsed from the last time you filed a petition in bankruptcy. So you've gotten through all this stuff. The deadlines to object to discharge or determine dischargeability have expired. There have been no objections filed to exemptions, and so now you wait for the order granting your client a discharge in bankruptcy. The discharge in bankruptcy is generally issued on the 61st day of the date from the date that you filed, or from the date of the creditors meeting. Once you get that, you're going to want to send a copy to the client, because they're probably going to get theirs in the mail. But if you get it sooner, it's nice for them to have it. And then you're going to file a report with the Dallas Volunteer Program, telling them exactly what happened. There's 4 or 5 questions that you answer, and then they can close the case. And that's basically how it works. And as I said, typically when you get the client, they've been vetted, and they're motivated, and they just need a little help, and they don't have a lot of money. And with that, I'll stop and open this up for questions.
Thank you, Rob. Let me go ahead and pull up the Q&A. Please enter any questions in the Q&A box for anything that you would like Rob to expand on or to cover through the remainder of today's presentation.
Oh, is that good? No questions.
Okay, here we go. First question. What do you do if your client keeps getting collection calls or letters after a bankruptcy filing?
You tell them to record the name and the number of the person that's calling. You have them provide that information to you, and you either call or you send a letter to them with a copy of the notice of the bankruptcy and advise them that if they continue to violate the automatic stay that's in effect on the date of the filing of the petition in bankruptcy, you will file a motion to show cause why they shouldn't be held in contempt and sanctioned for violating the automatic stay.
Thank you. Another question. Can you please talk through the rest of the process after what happens when you file?
Okay. Um, Notice goes out to all of the creditors. You've prepared a matrix. And in order, there's a form that the Northern District of Texas uses, or a format that the Northern District of Texas uses to send out notice. The notice is done. You don't pay for the notice. The notice is sent out by the bankruptcy court, and it's sent to all of the creditors that are listed on the matrix. So it's important that you get good addresses and that you've got everybody that you've gotten, or you've listed all of your creditors. You've gotten your client to give you everybody that they wanted to include in their bankruptcy. Um, so the clerk's office will send out notice of the bankruptcy. Then between the time of the filing and the date of the creditors meeting, really you might get a call. I can tell you that in all of the cases that I've had for the Dallas Volunteer Attorney Program, I don't think I've had one creditor call me. And these um, they typically don't have the kind of debt that people that have had a lot of money or had taken risks do, or that have run a business. Typically, the people that the clients that we get from DVAP um, don't have those issues. Um, so anyway, then so you wait for the meeting of the creditors, and what I typically do is about 2 or 3 days before the creditors meeting, I either set up a video conference if my client can do that, or I have them come into the office, or I get them on the telephone. That's sort of the last choice. And I go over all of the questions that I'm going to ask them and that I think they will be asked at the creditors meeting, so they are prepared. I mean, I want my client to be, and I do this for all of my clients, whether they're the Dallas Volunteer Attorney Program or somebody else. I want them to be prepared to be comfortable, as comfortable as they can be with the process and with the questions they're going to be asked. And if they know and they have an idea, then it's they're a little bit more confident. They answer the questions directly. They follow your advice and they answer the question. They don't go off on a tangent, and it moves fairly quickly. After that, creditors meeting is concluded, then you just wait for the discharge. Once the discharge comes in, you're done.
Great. If I file an amendment, do I have to notice the creditors?
Yes. If you didn't list, if you're filing an amendment, the procedure typically would be you file the amendment and then you send a copy of the notice of the bankruptcy that was issued by the court to the creditor who you added to the list of creditors. And the reason you do that is the matrix is sort of fixed, um, and they're not going to send out individual notices. They'll send out blasts, for instance, when the discharge is entered, they'll send out notice, and if the matrix has been amended, that creditor will get notice of the discharge. But in between the time that you file and the time that the discharge is ordered, there's really not a lot of there aren't really any documents that the court sends out, and so you need to notify the creditor yourself. And just as an aside, it's important that you notify all the creditors. But if something happens and you don't, um, typically these are no asset cases, and there are cases out there that say that if it's really a no asset case and the creditor isn't notified until after the discharge, that there's really no harm and no foul. You give them notice, and they know they know that there's a post-discharge injunction from contacting your clients, and that's the purpose of notifying them after the fact. But they don't really, there's really no harm in the fact that they didn't get notice until after the discharge. So get them listed, try to avoid that, but know that if that happens, that you're probably okay. You just want to make sure your client's protected.
Okay, next question. Um, Please address advising the client with regard to coming into money via potential lawsuit as a beneficiary of a will or lottery winnings, etc. How
Yeah.
is that dealt within the filing?
Glad you raised that. That's one of the unusual issues that I meant to address. Yeah, one of the things you have to do is they have to list all of their assets, and a lot of times um, clients don't realize that if they've signed a contract with a personal injury lawyer or they've got a claim for some kind of medical device that was implanted 10 years ago, um, anything like that, they have to let you know if they know about it at the time of the filing of the petition in bankruptcy. And it needs to be included in the schedules. If they forget about it, um, and you find out about it later, it may still be okay, and they may still be able to participate in any distribution or any proceeds that they receive from those claims if it's actually truly inadvertent. If it's intentional, it's another issue. Um, and even then, there are some issues about whether or not you can deprive them of the exempt portion of their proceeds. So and in the typical case, what happens is they don't list the personal injury claim that they've gone to see a personal injury lawyer about. The personal injury lawyers typically run bankruptcy reviews, and they contact the trustee. The trustee is going to contact you as the attorney for the debtor, and then you'll deal with your client. And again, if it's truly inadvertent, you just add it, you amend the schedules, um, and you add the client. But let me step back again for a moment. Typically, you don't find out about these things the trustee doesn't find out about these things until the case is closed. So the trustee will file a motion. If the trustee believes that there's a benefit, there's potentially a benefit for the creditors, the trustee's going to file a motion to reopen the case and will be reappointed. And then he'll deal with the personal injury lawyers and see if there is any benefit to the bankruptcy estate, and the trustee will try to keep as much of that money as possible for the benefit of the creditors. That's typically how personal injuries work. Inheritance is there's a provision in the bankruptcy code in section 541 that deals with property of the estate that says that if you become entitled to an inheritance, become the beneficiary of a life insurance policy, or you are a beneficiary of a settlement arising out of a divorce decree or a marital property settlement, that's property of the estate. Your client has a duty to supplement the schedules, notify the trustee, and notify the court. And then if that maybe after the case is closed, if it is, the trustee will reopen the case. If you can claim it exempt, you're able to do that. If you can't, it becomes property of the state for the benefit of your creditors. Now, windfalls are a little bit different. There's not and if you go to a creditors meeting, a lot of times the trustees will say, if you become entitled to an inheritance, or actually the debtor's attorney typically goes through this with their client. If you become entitled to an inheritance, win the lottery, uh, find $10,000 on the street, you have to report that to me, and that may not be um, uh, your money. It may belong to the bankruptcy estate. That's not exactly accurate. What happens is if there's a provision in your well in Schedule I and Schedule J that asks you if you expect any kind of a significant increase in your income or a significant decrease in your income in the immediate year in the next 12 months. This doesn't really fall into that, but it's in the same vein. If you win the lottery within 180 days of the date of the filing of the petition in bankruptcy, really arguably within a year, you have a change of circumstances. And the trustee or the U.S. trustee's office can file a motion to dismiss your case under 707B or 707A because you have had a change of circumstances and you have the ability to repay your creditors. So either way, you've got an obligation to notify the court if there's a change in your circumstances. And then you may choose. I mean, as a lot of people tell you, as a lot of the debtors will tell you, if I won the lottery, I'd pay everybody I owe money to anyway. Nobody wants. I won't say nobody. It would be. I haven't met anybody that came into my office that said I just couldn't wait to file bankruptcy. This is the opportunity of my life. So that's what happens with windfalls, inheritances, personal injuries.
Great. Do you find that it's a challenge to get clients to provide all necessary information in their questionnaire? Do you typically do frequent follow-ups to get them to complete it?
Um, First, well, the answer to the question is not really. Most of the time, they list everything they own, mainly because they don't really own a lot. When we're talking about the referrals from the Dallas Volunteer Attorney Program, um, I've had so in this instance, and they're motivated because they want to get out from under the debt, and part of the motivation can be that they're at a point where they're hoping that their life is going to turn around. They think they're going to get a job that's going to pay them some money. They want to clear out all of this debt, and they want to make sure that they get their discharge. So they're pretty motivated for the most part. I haven't really had an issue with Dallas Volunteer Attorney Program referrals not um, answering questions or providing the information. Now, sometimes they don't understand what an asset is. They don't understand. They may not understand that a claim can be an asset or a lawsuit can be an asset or maybe they're entitled. They inherited some land in East Texas someplace along with five other siblings, and they may not understand that that has to be included. And so we have a list of questions that we kind of follow up on. And when we go through the schedules with them, we make sure that they don't don't have any real estate, don't have any mineral interest, they don't have any timeshares. That make sure that they understand that we're talking about any kind of interest in real estate. Um, and sometimes if you can get the client to pull a credit report. I'm sure you all know that everybody's entitled to one free credit report a year from each of the three credit reporting agencies. And so sometimes if you can get them to pull a report, a credit report, you can see if there's something on there that they may have omitted, uh, uh, or that needs to be listed. Um, but you have to rely on their honesty, and you have to be kind of diligent to make sure that you pat them down sufficiently that they've answered all the questions and you feel comfortable that there's not anything else out there. And again, you don't really, I mean, typically with the referral from the Dallas Volunteer Attorney Program, you don't have a problem.
Great. So these next couple of questions seem to be a little bit more case specific. So just I think asking your thoughts. Um, One attorney has a widower who would like to file for bankruptcy. She has not probated the will, and the estate owns a home. What are your thoughts on filing for bankruptcy?
Does she live in the house? I mean, well, okay, let me just, okay, so if there's a house in the estate and it's her homestead, then it's her homestead. Unless, and she has a homestead interest in that, and typically, um, um, in the typical case, the surviving spouse has at least a lifetime, a life estate in the homestead, and probably in most instances would inherit all of the interest in the real estate. So would I have a problem if the will hadn't been probated and that was her homestead? No, you just list it as homestead and go forward.
Thank you. If a client has a surplus of income because they live with their parents, say $500 a month, what would happen if they filed for bankruptcy?
Probably they would get their discharge, and $500 a month wouldn't really be, I mean, again, it depends on the amount of indebtedness they owe. In order to in, in order to force somebody either into a Chapter 13 or to dismiss the bankruptcy, the surplus income has to be a meaningful distribution to their unsecured creditors. So, and that's over 60 months. So, $500 over 60 months is $30,000. And if they had, you know, $150,000 in debt, that's not necessarily a meaningful distribution. So probably nothing if it's $500. If the amount of their unsecured, the amount of the unsecured debt is, $50,000, then maybe they get forced into a Chapter 13 if they really have a surplus of $500 a month. But it's a function of, is there going to be a meaningful dividend to the unsecured creditors?
Okay, another one. Attorney had a 341 meeting yesterday, and they need to add a new creditor for a hospital bill that the client received after filing. Does the attorney need to attach the 341 meeting notice and a proof of claim to the amended schedule?
Um, Probably not the proof of claim, but yes to the notice of the meeting of creditors. Um, and if you want to, you can just take the page of the schedules that you've amended and send it to the creditor to let them know that that the schedules have been amended and they've been added. But you don't have to send a proof of claim. Most of the cases that are filed as Chapter 7s are noticed out as no asset cases.
Okay, and last question. When a filing fee is waived in an NDOT, it has to be manually filed outside of the e-filing software. Is there guidelines or how to do that in in order to assist with the process, or is that something that you recommend that you've done before?
Okay, ask the question again because I'm not sure.
Yeah. When a filing fee is waived in an NDOT, it has to be manually filed outside of the e-filing software. So is there someone or process that would assist with doing so?
Oh, I don't.
And
And tell me
perhaps
what
we
an
may,
NDOT is.
they do not. So whoever answered asked that question, if you could provide some further clarification, hopefully we can get your question answered. Um, oh, N Northern District of Texas.
Okay, I'll have to remember that one. Uh, if you file the IFP and you file the motion to proceed in form of papyrus, there's an order. I mean, you file that electronically, and then the court enters an order granting or denying the IFP. Um, I'm not sure. I don't. I mean, when you say file it manually, I'm not sure I understand what you're going through. I mean, because there's a way to do it on ECF.
So it says the attorney says when filing in next chapter, you cannot electronically file. You cannot use the software.
Oh, I don't use an X chapter or whatever it's called.
So then,
I,
what are there other filing systems you would recommend?
uh, we switched to Blue Stylus because it was relatively less expensive than the system we were using, but it's a little bit tricky and it allows you to file, it basically allows you to file directly from the program to the Northern District of Texas. But you need to work with that a little bit because it's got some quirks in it that we've discovered. We ended up, ended up filing a case it was in the Northern District of Texas, but it ended up in the Abilene Division, which is okay, but it wasn't what we intended to do. So yeah, I mean, that's what we use.
All right. Yes, any specific questions can be addressed to our mentors, and I will provide their contact information following today's presentation as well. As we are towards the end of our hour, I will go ahead and provide the MCLE course number, and that number is 174-313-247. Again, that is 174-313-247. So we kindly remind everyone to file their own MCLE credit using their State Bar of Texas profile. Seeing no additional questions. Do you have any parting words, Rob, before we end today's session?
Yeah, I do. Look, it's really great to work with the Dallas Volunteer Attorney Program. They give you a package that basically sets up your case so that you've got all of the information you need. They're there to assist. You can call them if you have any questions. You can, if you've got, when you go through the packet, if you need a clarification, they are there to assist. And this really, and you really are providing a service not only to the client, but to the system and to the trustee. And it is worth the time and the effort in helping the people that come to the Dallas Volunteer Attorney Program because they need the help and they're very appreciative. And you'll feel good about it.
Great. Thank you, Rob. And we did have one last question. If you're not barred in the Northern District of Texas, DVAP can provide you instructions on how to get barred in order to work on these cases. So if that is a concern of yours of not being able to take the cases, do not worry. DVAP can assist in that process as well. So without further ado, thank you, Rob, for today's presentation. Thank you all for joining the April session. We will come back next month with a new topic, and thank you, everyone, for your time. Have a good rest of your afternoon.
All right. Thank you.